Good afternoon, everyone. My name is Alexis Alvarez. I'm Director of Statewide Training here at Florida Legal Services. Happy Friday. Thank you for joining us for the second part of our training series in honor of Domestic Violence Awareness Month. I really appreciate all of you that do this type of work, those of you who tuned in to learn more about this type of work, and certainly our speaker who is very experienced in this realm and this field. So before we get into introductions and move into the substance, I want to give some time for folks to trickle on in, and I'll give some housekeeping announcements. First and foremost, this is being recorded, and a copy of the recording will be sent to you all via Zoom within 24 hours after this event. If you don't see that email from Zoom in your inbox, you can always email me directly. I'm going to pop my email into the chat. Reach out to me for anything you need. Second piece of housekeeping announcements are the closed captions. Anyone that needs a little bit of extra accessibility, that's there for you. All you have to do is press show captions under the more button on your Zoom. Everyone's different, Mac, Windows, Chromebook. So if you're having some trouble and you can't find what you need, again, you can email me. I'll drop my email into the chat, or you can chat me directly. It should go directly to me and I'll help you out. Third piece of housekeeping announcements is CLE credits. I know you all are here to learn, but also some of you are here just for the CLEs, and that's okay. I do have this course approved for CLE credit, and I will put that CLE code into the chat at the end. I will also say that CLE code out loud, and that CLE code will be included in the email from Zoom with the recording within 24 hours after this event. Always, I always feel like I missed something with housekeeping. So I might pop back in later on or say something new at the end. But with that being said, I want to move into introducing our speaker. And I don't even think I said the full topic of today's training. I'm sorry about that. We are here for empowering resilience. This is a trauma-informed wraparound legal services for survivors of intimate partner violence training. And to talk to us about this important topic, we have Nicole Avila, who is not only an amazing friend of mine, an amazing colleague of mine, and really just an amazing advocate in the sphere of survivor work. I'm very honored to work with Nicole. I'm very honored to call her a friend, and I'm very excited to learn from her, and I know you all are too. And so with that being said, Nicole, I'm going to turn it over to you to sort of tell folks a little bit more about yourself, your experience, and a little more about what we're going to talk about today. Thank you so much for being here.
Of course. Thank you so much, Alexis. So I am Nicole Avila. I'm an attorney here at Florida Legal Services. I am a supervising attorney in our survivor advocacy project, and I focus primarily in the practice of immigration law and crime victim rights law, with some injunction in family law here and there. And I also do some hotline work here, and I've been practicing in this field for about 9 years now, in my 10th year of practice working with survivors. And thank you so much for being here. Please feel free to drop questions in the chat, and Alexis, if you can keep an eye on the chat, and you can sprinkle in questions as they come in, and if they're relevant to the topic, I'd super appreciate it.
Sure, of course, that's the housekeeping announcement I missed. I knew there was something.
Perfect. So like Alexis said, this is Empowering Resilience. We're going to talk about how to represent clients in a trauma-informed way and work in multidisciplinary teams to provide wraparound legal services for survivors. So let's get started. Today, my hope is that by the end of this presentation, you'll be able to understand trauma-informed care, define trauma and its impact on survivors of domestic violence and intimate partner violence, recognize the importance of trauma-informed legal services, identifying the needs of survivors, the specific legal issues faced by survivors of domestic violence and intimate partner violence, analyzing the legal challenges they encounter within our justice system, implementing trauma-informed communication practices, and to interact sensitively with survivors, and helping them to navigate the legal process effectively, minimizing re-traumatization, working in collaborative teams, and Also, identifying your own signs of vicarious trauma and compassion fatigue in our practice, implementing not only self-care but community care, and promoting access to justice through the trauma-informed lens. First, I'd like to start with some definitions so that we're all starting from the same starting point and assumptions. So intimate partner violence is defined, or an intimate partner is a person with whom one has a close personal relationship that may be characterized by the partner's emotional connectedness, regular contact, ongoing physical contact, and sexual behavior, identity as a couple, familiarity and knowledge, lives, and the relationship doesn't need to involve all of these dimensions, but this is the framework that we're working within. And intimate partner violence includes physical violence, sexual violence, stalking, and psychological aggression, including coercive tactics by a current or former intimate partner. It can be a spouse, boyfriend, girlfriend, dating partner, or ongoing sexual partner. Now, the definition of trauma that we're using is what results from an event, series of events, or a set of circumstances that is experienced by an individual as physically or emotionally hurtful or life-threatening, and that has lasting adverse effects on the individual, on their functioning, mental, physical, social, emotional, and spiritual well-being. A trauma exposure response is the transformation that takes place within the person as a result of exposure to the suffering of themselves or other living beings on the planet. And then the framework that we're using for trauma-informed representation is the type of representation that realizes and takes into account the impact of trauma and understands potential paths to recovery. And it recognizes signs of trauma in clients, staff, and others within the legal system. And a representation that is responsive by integrating that knowledge of trauma into policies, procedures, and practices to actively resist re-traumatization of our clients and people that work within the same systems that we do. The principles that we're working under as part of trauma-informed representation. So what we're talking about is not a prescribed set of practices or procedures. There is no checklist or manual or elements like we know about in torts or contracts and things like that. So, but it is an approach that reflects adherence to these 6 principles. So I'm not going to be able to give you a prescribed set of practices, but having this as the guideline and framework under which we work, considering the safety of our survivors, and that is their physical and emotional safety, working with trustworthiness and transparency, peer support, collaboration and mutuality, empowerment, voice and choice, and recognizing that there are cultural, historical, and gender issues within the systems that we work in that also cause trauma. So what does this mean for our legal practice? So here are some practice pointers, and then I'll go over how I've implemented some of these into my own practice. So the first thing we talked about was a safe environment, and we're talking about physical safety. So we want to establish a safe, comfortable, and respectful environment for the client when we're meeting with them. We work remotely, so most of my interactions with clients in the last few years have been either over the phone or video. I give the client the choice whether they prefer to meet on video and be able to see my face, or if they prefer to just meet by phone. Folks have different preferences. If I do have the opportunity to meet somebody in person, for instance, at our office in Orlando, I have met several clients in person, especially when we're dealing with law enforcement interviews. So one of my practices is to have water, tissues, and fidget toys available on the table. I don't even say anything about them. I just put everything in front of where the client is going to sit, and folks will usually just reach for it. The fidget toys are very helpful for managing anxiety during interviews or when you're taking declarations or getting statements from your client. So it's an important tool that kind of helps to guide that energy and keep folks grounded into the present moment. We also need to be very mindful of our communication style and the language that we use to minimize re-traumatization. And what I mean by that is we as lawyers are trained to think in certain ways. We're trained to think in elements and checklists to see if there's relief. And that is an important piece of this. But when we're working with survivors, with folks who have undergone severe trauma in any form, we have to be very cognizant of that and be mindful that while this is a legal issue that's going to go in front of a court potentially and all of those things, we are dealing with a person, and this is a thing that happened to that person. It is not their entire life. And there are, just like in our lives, we have different facets and different spaces and environments we inhabit. Our clients do too. So recognizing that they're a whole person who has experienced trauma, and this is a part of their story, not the whole story. Recognizing also that is something that happened to them and not something that they did. One question that tends to come up, especially with law enforcement interviews, is why? Why did that person do this? And so when we're talking about why did the abusive party act like an abuser, that is very much not a trauma-informed question, right? Because why would our survivor know that, first of all? And second, that we know as practitioners in this field that domestic violence is about power and control. It is about the abuser acting in ways that they believe will get them power and control over the other person. So, but that is often a question that survivors of intimate partner violence and human trafficking get asked by law enforcement. And sometimes, even when we're doing declarations for immigration cases, for instance, we have to get to the effects of the abuse. Especially if we're talking about cases that are more heavily reliant on the site, or that were more tending toward psychological, emotional, financial abuse rather than physical abuse. So, but we have to be very mindful about those questions. And when we do have to ask a question like that, I typically preface it by saying, I know that this is a horrible question, and I know that you wouldn't necessarily know the answer to it. But if that person gave you a reason, or if that person said something to make you believe they were doing this for a specific reason, or what would happen if you didn't do what you were told, the things like that, I typically preface it by being transparent and letting them know that this isn't, I'm not passing any judgment. We're just trying to build the case and be transparent about why you're asking that question, and why that information is necessary in the case. Prepare your client for proceedings, set appropriate expectations, and answer questions. When we talk about this, we might go to court all the time. And hopefully our clients have not had to go to court all the time. See if there's opportunities. If there is Zoom court, then that's, kind of a different thing. And you can do a practice run with your client. If you are going to court in person, if there's an opportunity and your client's available where they can maybe see the courtroom or a courtroom in your jurisdiction on a day that is not their court hearing, that might be helpful, or even going through photos of what that might look like to kind of ease their anxiety about being in court. They've now seen the space, and so that's one less unknown. Walk them through the process, walk them through what your role is in court, what their role is in court, and who else is expected to be there if this is motion calendar hearing where there's going to be a ton of people, or if it's going to be a closed court, let them know and walk them through that process as best you can. Prepare them, especially if they're going to be providing testimony, prepare them to not only receive questions from you, but from opposing counsel, who is not going to be their friend and who is oftentimes not necessarily trauma informed, and their purpose there is to help their client. So be transparent, and clients, it's not going to be a pleasant experience, especially if they're getting cross-examined, but it is important that they have at least a run through prior to of what this might look like for them. Active and set expectations for the client. We cannot fix everything. There are a lot of things that are outside of our control. And so that's where that's usually how I have that conversation. Is I go through, there are things that are within my control, and this is what I can control, and this is what the client can control, what my role is in the representation, if what pieces I am handling, and if I'm working with other attorneys, what pieces they're handling, and what the client's role is in the representation. And then setting clear expectations that are reasonable as to potential outcomes. Don't overpromise anything. Don't be very transparent with the client on what you believe the outcome might be, what the risks are to them of filing the potential relief in whichever area of law you're working in, and answer questions. There's some literature out there that does say that folks who are in crisis or have undergone trauma recently might only be retaining about 1/4 of what we say. So what this means for us is that we might have to answer those questions multiple times. If I have a client who emails or texts, I'll try to answer questions by email or text so that they can refer back to them. You can also develop for your program client written materials with kind of FAQs on how the processes that you do often work, what the client's responsibilities are, what the attorney's responsibilities are, and things like that, so that the expectations are set appropriately from the outset and the client has something to refer back to in case they have questions. Another important point on the safety and trustworthiness and transparency is to acknowledge that there is always going to be a power imbalance between you as the attorney and the client in the representation. It's inherent in the work that we do. Oftentimes, we'll also have the client will be from a different community than the attorney, so the levels of privilege will also be unbalanced. So do what you can, what's within your power, to balance that power back and give some of that power back to the client in the parts of the representation that belong to them. So empower your client by providing them information on outcomes and risks so that they could make informed choices. I do have a lot of clients who oftentimes will just try to defer back to me and, well, you're the attorney. So understanding that you as the attorney in your position have a lot of pull, and what you say has a lot of weight for the client, and teaching them about the process and empowering them to be able to make decisions alongside you and work collaboratively with you and anyone else that would be on that multidisciplinary team, which we're going to talk more at length about a little bit later. But so that the client knows what parts belong to them and they're able to make those choices with your guidance, but giving them some control and power back that they've lost throughout this traumatization. active listening, avoiding eliciting non-relevant details of victimization. I think this is a very important one, especially when we're talking about the immigration cases. Oftentimes I see practitioners put things in their declarations that don't really go to the legally relevant parts of the case, and maybe are just eliciting emotional information that's going to elicit an emotional response from the reader. And one of the things that we talked about initially in our definition of trauma-informed practice is that we need to also consider the impact of trauma on the people that are part of the system that are going to be reading what we're presenting. And so if it's not relevant to the case, and the only reason we're putting it in there is to elicit an emotional response, we're eliciting that information from our client who has lived through this. And it's important that we steward their trauma and that we guide their process in consideration of their trauma and how this affects the client, primarily in having to retell these parts of their story that, other than having purely emotional responses of the adjudicator, are not necessarily going to help the case. And as by way of example, oftentimes I'll see folks put in gratuitous details and gory details of sexual assault, or physical violence, where the fact that it occurred is enough and the intimate details of how it occurred are not necessarily going to strengthen the case in any way. And so having your client retell that and being exposed to that secondary trauma, and the potential adjudicator also being exposed to that trauma, it makes it harder for everybody working in the system, and especially for our client. We also want to validate their experience and advocate for protective measures in court appearances, if perhaps we can have them testify in camera or through closed circuit television, with a facility therapy animal, things like that, that will make their experience a little bit easier and minimize re-traumatization. We're not going to be able to prevent re-traumatization because the system is not meant to deal with people's trauma. But that's what we're here for, and why we want to work in multidisciplinary teams and bring in the folks who do what I sometimes call the touchy-feely stuff. We're lawyers. That is not our area. We don't do the feels and the warm fuzzies. So we need to bring people in who are the experts in those arenas to help the client deal with all of the facets of the legal system. On empowerment and choice and working collaboratively, like I said, explaining roles and expectations, do this early and often throughout the representation. Again, folks might not be retaining everything that we say, and we are going to be telling them a lot of things that will have a large impact on their lives. And sometimes folks are not in a position to hear it. Sometimes they're not ready to engage yet. And so we have to be cognizant of that and connect them to the services that will support their recovery out of the trauma and the crisis situation, and give them the tools to be able to navigate the system. We want to keep clients informed and provide them tools for informed decision making, respecting their autonomy and choices, even if those choices are not the ones that we would make. We, as attorneys, have a different vision of what the system looks like and what are within our role. And the client is not going to have that same experience with the system that we do. The client's priorities might be different, and that is completely okay. The client is the expert in their lives. They have kept themselves alive this long. So when a client tells us they don't feel comfortable reporting to law enforcement, even though that is the only avenue that they have for immigration relief, or they don't feel comfortable going forward with an injunction because it's not going to be enough protection, we have to be okay with taking no. We can tell the client what the risks are of not going forward and allow them to make that decision themselves. They are the experts in their own lives and they can make the best decision for themselves. I've seen where sometimes folks in the private sector get upset because the client is unresponsive or does not prioritize the legal services or is not able to make the payments on time and things like that. And we need to consider that every time we're speaking to the client, because of the area that we inhabit in their lives, the role that we play in their lives is necessarily connected to their trauma. And human beings are wired to avoid pain. So if every time I have to talk to my client, I have to bring up the fact that we're going to court and they might see their abuser, or that I need to sit with her for another interview with law enforcement, and this is the third time that we've done this already, then it's easy to see why folks might not be responsive. And this is going to vary client to client, but their response to dealing with this trauma is going to vary even from day to day. And that's why it's crucial for us to have them connected to services if they're ready to accept them and they're ready to engage with services like counseling, case management, so that those folks can help them navigate the areas outside of the legal system. We want to make sure that folks that we're engaging with, that we're not pushing them to do something they're not ready to engage with, because it's harmful to the client, it's harmful to the case, and we might end up putting them in a worse position than when they started. And recognizing which parts are ours to own, like legal strategy, and which parts belong to the client, and empowering them to make those decisions and being okay with whatever decision the client makes. It might mean like, listen, I'm going to close your case for now. Please feel free to reach back out if anything changes. But there is nothing else that I can do, but these are your rights and these are the options that you have. And it might be that they work with a counselor for a while and then they're ready to engage once they've unpacked some of that trauma and have separated from the crisis situation for a while. Again, referring clients to supportive services, and I think I have this on a lot of slides, but it is really a huge, huge piece of representing folks in a trauma-informed way, because again, we are not experts in every single part. We're not even experts in every legal field that is implicated in intimate partner violence cases. And so we are not therapists, and oftentimes we might be the first person that the client has disclosed the trauma to. And that puts us and it puts the client in kind of an odd situation where clients might just unload all of their trauma because you're the first person who listened. We see this a lot on the hotline. My particular strategy is I'll let them talk and kind of get out, especially if this is the first time they've talked to somebody about it. I'll let them talk for a while, and then I'll narrow down the issues and I'll ask questions so I can determine relief and legal needs and social services needs for them so I can refer them appropriately. And I'll explain, like, this is my role here. I can answer legal questions, and this is the structure of the representation, and this is what I can do for you, whether it's assisting them with an injunction or they're eligible for some sort of immigration relief, etc. We'll provide the options to do that, but as soon as we can and as soon as the client's ready, having them refer to supportive services. We also want to work with the service providers within the bounds of our own confidentiality and their confidentiality, so that we can minimize the re-traumatization. So if there's any conversations or interviews that we can do together, for instance, if you're engaging in a co-counsel relationship with a family law attorney because you're an immigration attorney and you don't have the tools yet, or you just don't want to do family law, which is totally cool. I don't like doing family law either, but so if you're engaging with another attorney, if there are parts of those conversations that can be done together so that the client only has to tell us their story one time, and we can ask our questions so that they don't have to go through this with multiple advocates multiple times, then coordinating with multiple parties to be able to do that. And find out what their restrictions are, before you refer folks. We've had instances in some of our programs when we've tried to refer folks for housing or other services where the intake process itself ended up being quite traumatic for the client. So if you're able to take a look at the intake process before you start referring folks to an agency, or have a meeting with the agency and see what their process looks like, what information they're going to elicit from the client and things like that, so that you're able to be transparent with the client as the person who's referring them to another agency. They've already built trust with you. So let them know, for perhaps the housing provider is a faith-based organization, and that may or may not be something that the client is okay with. So letting them know, listen, this is a faith-based organization. It's my understanding that they do have spiritual services, or if they're a Christ Center program, there's going to be religious services that are part of this program that you will have to engage in if you do choose this program, and let the client make the choice. But that way you have provided them with the tools to make an informed choice and be able to decide for themselves if this is an okay fit for them or if it isn't. We were unfortunately in a position where once we started the intake process, it asked about things like the client's relationship with God, and with religion. And in that moment, that client had only just separated from the crisis situation and was not able to respond to that question. And it was a question that at an intake stage seemed incredibly traumatic for her. I think her response to us was something like, I don't know, I'm really mad right now. All of this happened to me, and I don't really know what my relationship is right now. And so we did not have an opportunity to assess that intake ahead of time, but it was a really good lesson for us to try and get that information whenever possible, way ahead, so that we know what we're referring folks into, and if it's allowing the client to make an informed choice of whether it's a good fit for them or not. Trauma sensitive language. Definitely avoid legal jargon. I know that I am super guilty of this, because we went to law school and our brains got broken there, and this is just how we talk now. But there's definitely a huge benefit to avoiding legal jargon, in that your client is not an attorney and they need to understand what is happening, the processes that they're engaging in, so that they can make those informed decisions. And so explain things as clearly as possible, avoiding legal jargon in the language that the client understands. And whether it is that you speak another language and that's the language that the client understands, or you engage with a language line or a translator, making sure that everybody's on the same page. Phrasing questions non-judgmentally. Again, the traumatic event is something that happened to the client. It is not something that they did or that they caused. So asking things like, well, why did you stay? And I think that one seems a little bit obvious in 2023, but I have heard officers and other folks ask questions like that in the past, and folks that are presumably trained in trauma-informed services. So making sure that we're asking questions in a way that is non-judgmental. If the client perceives us to be judgmental, we're not going to be perceived as somebody who's safe for the client to disclose things to. And we're not going to be able to do our job effectively or ethically. We're not going to have what we need to be able to get that best outcome for the client or to guide them and steward them through this process. Avoid labels, including victim or survivor, depending on the client. Ask the client how they would like to be called. Make sure you're using their appropriate pronouns, that you're using the names that they refer to themselves as, and including what labels and what names they would like you to use for the perpetrator. In one of my cases, the perpetrators are the parents, and one of them is a step parent. So our client asked us to call him by his given name, because she does not consider him her parent for a very good reason. So be mindful of those labels if you are somebody who is maybe forgetful, and we have to keep track of a million things a day. And I totally get it. And I am one of those people. I'll put an alert on my case management system of things like that I need to be extra mindful of. So every time I open the case, it's there. And when I open the case, because I'm going to be speaking with the client, it's there, and things like that. So wraparound legal services. When we're talking about wraparound services, what we're talking about is there's tons of interrelated legal issues in intimate partner violence cases and survivor cases in general. There are so many areas of law that can get implicated when survivors are trying to leave a crisis situation and navigate the legal system. Some of the common things that we see are injunctions, immigration cases, family law, housing, victim rights, and I left the sixth one blank because it could really be anything. We've seen even issues of image and likeness and intellectual property, ownership rights that are implicated and things like that. So it can really be essentially any area of law. And so again, we are not the expert in everything. And it's important that we work with folks who are, or that we get the mentorship and guidance that we need to get to that point. Because I think most of us on this webinar are in legal aid. I know, and I get, because I'm in legal aid too, that we do a little bit of everything. And that's sometimes what's expected within the constraints that we have from our funders. But it is really important that we engage, whether it's pro bono or do additional trainings and things like that, so that we can handle different areas of law. So wraparound legal services brings together legal practitioners, service providers, and clients with the goal of providing support and representation in multiple areas of law affecting the client's case. And I can't see your faces, but I'm assuming some of you are looking at me like this, like I already have a lot of work, and how can I do all of the things? And we don't want you to do all of the things. We want you to work with folks in the area that can help you do all of those things, and work in multidisciplinary teams. So we're on a Broadway kick at my house because my daughter does musical theater after school. So no one is alone. We want to work with folks that can guide the client in the areas that we are not experts in. So a domestic violence multidisciplinary team is a group of professionals that represent various disciplines and work collaboratively from the point of initial report of the abuse to assure the most effective coordinated response possible for every victim. This includes attorneys. We may be working with law enforcement if we're reporting a crime. There might be medical providers, therapists, state attorneys' offices, victim witness liaisons, or a multitude of people, social services agencies, counseling providers, and civil legal aid. And now, while we're not going to engage and get all of the information about their therapeutic relationship and things like that, that's not our area. We're going to make sure that they're connected. And when there is a need for us to communicate that the client has given permission for that to happen, and that we're only providing as much information as we're allowed to through the guidance of the client and protecting their confidentiality and the privilege, but that we are working together to reach the best outcome. Because again, this is only one piece of their lives, and it's going to affect a lot of things. And so navigating, like, I'm only going to do your divorce, here you go. And I understand we all have huge caseloads and are overworked, but at least connecting them with agencies that can do the other parts and working together as much as possible. So, and not leaving the client to just kind of navigate the legal system alone when the power generally lies with the abuser, and the abuser can use that power to continue to perpetrate abuse against our client through abuse of the legal system. Oftentimes we see this a lot in family law cases where the outcome or the desired outcome or the just outcome might come at the end, or it might never come. But in the meantime, while the case is pending, so many things can be filed and done and said by the abuser that put the client in the same space that they've been in while they underwent their trauma. And so having you as an advocate on their side to guide the representation and curtail those behaviors if possible, ask for sanctions, things like that, to prevent that trauma from escalating, and guiding them and letting them know this is what's normal, this is what's not normal. They can do this, they cannot do that. And so that they're not just kind of floating out there on their own, believing that there's nothing that they can do to solve these injustices. Of course, we know that in the systems that we work in, a lot of times there are no just outcomes. And the system, again, is not built to deal with people's trauma. So it's important that we become practitioners who know how to deal with trauma so that we can make those changes at least little by little within our organizations and within the systems that we inhabit. And I think we've come a long way, but there's still a long, long way to go. And it's important that by guiding our client in that way and connecting them to the services that they need, they're able to be to recover from the trauma and start building their own lives independent of their abusers. And while their trauma is always going to be something that happened to them, and they might have trauma exposure responses as they continue through life, minimizing that as much as possible in the roles that we play. Now, I have a note on self-care, because at the outset in the definition of trauma-informed representation, I mentioned that, it includes being cognizant of trauma of everybody that's engaged in the system, and that includes us as practitioners. I really, really hate the term self-care, because we inhabit systems that are inherently unjust. We are taking in people's trauma, and we get to see the best and worst of humanity in our jobs. And it's very difficult to mesh that with the self-care that we see on social media or TV or whatever, where it generally comes across as take a bath, have a glass of wine, that type of stuff. And while those are some avenues of self-care that, hey, treat yourself, those are awesome when you can do them. But that is not the end of it. on self-care. We need to be cognizant, if we're supervisors, of the trauma that our staff is going through. Our organizations need to be built to keep staff safe in that way, and give staff the resources and give all of our advocates the resources for longevity in this field if they want it, and to do this work sustainably. That means and that includes funders too, and making that part of our everyday, I like self-maintenance better. There are times when we need to do kind of the emergency self-care, where maybe we had a call that was just extra rough and I need to go take a walk right now because I'm not going to make it through. But also having a practice that is consistent, or as consistent as possible, of something that brings you joy and allows you to disconnect from the work when you are just not on. And whatever that means for you, it's for you to exercise, and also caring for each other within our organizations and our families and the communities that we're part of, being there for each other. So, and knowing that we're going to need the other people in our community to be there for us sometimes too, and that's okay. So I did want to leave you with that note on self-care. I'm going to send some resources to Alexis that you can access on organizational self-care, emergency self-care, and self-maintenance, things like that, and some resources on everything we've talked about today. One other resource that I like to share, and I always recommend folks who work in this field to access, is the Trauma Stewardship book. It's by Laura Vandernoot Lipsky with Connie Burke. And it's a really fantastic book that goes through how we internalize the trauma that we are exposed to, and how we can be better stewards of that trauma. We're exposed to trauma not only from our clients and our own lives, but the systems that we inhabit, all of the injustice that we witness, especially in this field, the gender and racial and historical issues that we know plague our systems. And so all of those are part of, that's why I like this book, because it doesn't just talk about, get in the bathtub and treat yourself, but also managing all of those things. And so I really love this tiny survival guide that they developed that goes along with the book. And so it gives you some tips on what you can do when you need, when you're surviving and stewarding other people's trauma and taking in other people's trauma. If you scan that QR code, it'll take you to the PDF for the tiny survival guide, and will give you those same pointers, and it takes you to the website where the book is if you haven't read it already. But I wanted to leave you with that, because while we are the ones that are taking in other people's trauma, we might not have taken it in firsthand, but any exposure to trauma is exposure to trauma. I heard a speaker once say that secondary trauma wasn't a thing, and we were all like, what? But what they meant was that any trauma is trauma, and our brain recognizes it only as trauma. And while the effects might be felt differently, it is still something that kind of shakes our perception of safety in the world. So it's important that we care for ourselves and each other as well. So that is it for my presentation. It looks like we have about 9 minutes for questions or comments or anything else.
Yeah, absolutely. Thank you so much, Nicole. It's always a pleasure to listen to you. You always remind me, of the bigger picture of what, when we're talking to our clients, and you always remind me to step outside of myself and really put myself as much as possible in the theoretical shoes of your client, right? Because I can't ever step into those shoes, but I really appreciate you providing that pause and that reminder, while also reminding us of what our role is and how we stay in our lane.
It's always a hard one. And I think especially in this field, like I said, sometimes we're the first person that the client has revealed the trauma to. And so, I know that I've done a lot of work on myself. And so I have all the therapy words, but that is not my role, and I cannot be their therapist.
Right.
And sometimes I'll give them, some encouragement. Like, this is, oftentimes we'll find that clients are judging themselves. I was so stupid, or I don't know why I did this, or why I stayed. And so giving them that encouragement, I think, is okay, without jumping headfirst into being a social worker, which we are not. And I have so much respect and admiration for them, because I just could not. And so it's important that we connect them with the folks that can do that for them, and knowing that we are not the ones that are going to take care of every single thing that is a trauma exposure response, thinking that we're the only one that can fix this. I am the only one that will do this.
Yeah.
And while we know that every program is essentially at capacity a lot of the time, oftentimes you're not the only one, and there are folks that can help in different capacities. I do see a couple of questions. So I see,
Don't mind reading some out loud. Whatever you're going to address,
yeah,
you can read it out loud, just in case
yeah,
anybody.
for sure. So I see Kanisha asked, who's in our MDT, and did we start the program as an MDT model? So our Survivor Services project started primarily as a hotline. And so we've expanded from that and have some different funding sources. It wasn't an MDT model, and we cover statewide services. So it's difficult. I don't have a straight up answer, because it's always going to vary by the client, the geographic area, what services are available. But oftentimes we have if we're talking about IPV, oftentimes we'll have the injunction attorney from the shelter injunction project. There'll be sometimes, if there is a criminal law component, there'll be somebody from either the police department or the state attorney's office that is a victim advocate. Any folks that sometimes, or usually for our human trafficking cases, we'll have a case manager. Like Lutheran Services has case managers, or Catholic Charities. And so they'll be coordinating other social services for them and communicating with us, just to make sure we're all on the same page. It's important, if you are engaging with law enforcement, that you are all on the same page, and because discovery issues might arise and things like that. So I'm usually very careful, especially with my non-citizen clients, and I think this is a whole other training, but that I'm not requesting anything at the outset unless it's absolutely necessary and we have no other option, because any defense attorney worth anything should be asking, were you given anything? Were you promised anything? And can get those documents in discovery potentially. So we want to be careful that we're being consistent with the narrative that we're of our client's story, and to whom we're sending it, and for what purpose, and being careful to safeguard their confidentiality. Let's see. For the purpose of understanding the situation, I do ask, why do you feel you have to stay? This leads to other questions about fear. Is there any other way to ask this question? That's a good question, Martha. I think it really depends on the client.
And Nicole, you broke up on my end. I don't know if folks are able to hear Nicole right now, or did Nicole freeze? Can people let me know in the chat?
Can you hear me?
You're good.
Okay.
They say in the chat you're good. I'm sorry. It must have been on.
Perfect. No worries. So in asking that question, I think it's going to depend in part on the rapport you've already built with the client. And again, being transparent that I understand, we know what the nuances are of IPV and DV and human trafficking. But the client's probably gotten this question from a few folks already, especially maybe support people in their lives. So we can preface it by saying, I know that you felt that, it wasn't safe to leave. Can you tell me what made you feel unsafe to leave? What, or what are some of the things? Was there, for our human trafficking clients, because we do have to establish there was force, fraud, or coercion for the labor or the sex trafficking. So we often ask other ways in which that might manifest. So were there weapons around, or what did you think would happen if you didn't do X, things like that. And just prefacing it with, I know that you were afraid and you could not leave, but I want you to share with me, like describe to me what made you feel that way. Um, and so I think it just really depends on the client and um, the rapport you've built that far. And if sometimes we don't have that much time to build rapport when we're doing hotline calls, we don't have that kind of time. And so I'll just say, like, this sounds like a really horrible question. I'm only asking because I know what law enforcement might ask or what you might put in your petition. And so I want you to know that I'm not judging you. I totally understand why you wouldn't have left. But can you tell me more about, that? So just being transparent and showing them that you're not judging why they did or didn't do something.
Right. You're human too.
Yeah, absolutely. Thank you for extending the discussion of self-care to include an organization's obligation to its staff and promote an environment that protects the mental health of the employee and not limiting the responsibility to the individual already traumatized employee. Absolutely, Michelle, that's a really great point. It's something that I think everyone in our organization has heard me talk about a million times. But it is really, really important. One of the things that we've implemented here is we have what it's informally called a reading group, where we go through, it started at first with our survivor advocacy staff reading trauma stewardship. But it's evolved to more of a processing space where we can talk to each other and have that peer support in how we deal with the secondary trauma. Kanisha also asked if we have any MDT members that are part of our staff. We don't at this time. I do know that there are some agencies like the Coalition Against Slavery and Trafficking in California that do have they have attorneys and they also have social workers on staff. That is that's one model. We haven't done that. I think that there are some issues that can arise with bar rules and things like that when we bring folks like that into the legal aid space because we are a law firm. So that would be something that I think you would have to discuss internally and see how you would be able to navigate that. But I wouldn't foreclose the possibility. I really love that CAST has case managers and that type of support in-house. But generally what we do is we refer out to other agencies that we've worked with.
Awesome. Well, thanks, Nicole. And I do want to just highlight that through the Q&A, something did come in, just a resource from Jeffrey. Apparently the family law section and OSCA are doing trauma in family law workshops around the state over the next 6 months. It says go to the family law section website for more info.
Absolutely, we are. And I know some of the members of our staff are participating in those. I think Betty Collazo is going to be doing some of the ones in North Florida, and I might be working on some of the ones down here in South Florida. So we are trying to educate the bench and the bar to be able to be better equipped to deal with folks' trauma in our courtrooms.
Awesome. Well, as always, I feel very lucky to work with you and Betty. I know Betty will be doing a training for us sometime in January. Very, very, very thankful to be working with all of you in this sphere. And I really appreciate you for bringing this conversation to the table. Just to let folks know, this wasn't my idea to talk about. This was Nicole's idea. It was something that she wanted to bring as a part of our Honoring Domestic Violence Awareness Month. And I can't thank you enough for, caring enough to share all of this great work that you're doing and sitting with us all in a sort of a community way of saying how we can all be better at serving our survivor population. So real quick before I let us close it out, just want to let folks know I did put the CLE code into the chat. That CLE code is 2309970, N as in Nancy. It is in the chat. Again, you will receive an email from Zoom, not me, from Zoom, in 24 hours after this event with the recording, with this CLE code. But as always, my email is up at the top of the chat. You want to just quickly copy and paste it. That way you miss that email or you need anything else. you can always reach out to me directly. And before we sign off on this Friday, thank goodness it's Friday. Is there anything that you want to say? I know you've talked enough. If there's nothing, if there's anything to leave us off with.
No, thank you so much. Thank you, everybody. You had amazing questions, and I hope it was helpful for you and for your practice.
Oh, I know it was. It certainly was. Well, and I should have put a plug in for the next one on the 24th, I believe it is. We will have crime victims' rights, and that'll be with Coast to Coast Legal Aid, the awesome folks over there. So please register. If you can't make it, you'll still receive a copy of the recording. If you need the registration, reach out to me, let me know. But I look forward to seeing you then, and I hope that you all have a fantastic, fantastic weekend. Thanks, Nicole.
Thank you. Thanks, Alexis.
Bye.
Bye.